Welcome everyone. Today we are going to discuss the non-disclosure agreement, in short NDA, or called as also confidentiality agreement, which describes its character and role. So this is the agreement that protects confidential information of the entrepreneur against unauthorized disclosure and use. What is the importance of these agreements?
It has a twofold impact. First, it directly protects our confidential information and data in relations with third parties, but on the other hand, it also has an indirect or more broad aspect concerning protection of our trade secrets and confidential information within the business, which is crucial at later stage to show that we kept sufficient measures to protect our information, or within a due diligence process when we are being examined by third parties in light of non-disclosure arrangements made.
So in fact, we have two situations in which we need non-disclosure agreement. First situation is the situation when we discuss, negotiate with our partner, and we have to transfer some information which is not yet protected by a patent, or other kind of information that we want to keep secret. The second situation pertains to our own personnel and relation with our employees or civil contractors who may have access to confidential information or who may themselves develop confidential information like inventions or trade secrets. So what can be the information that we want to protect?
Actually, any kind of information can be protected within NDA, which we perceived as confidential and which we think has value for our business. Just as an example, this can pertain to technological or technical information concerning
financial data.
Like financial data as well, of course, undisclosed inventions, for example.
Strategic plans of the given company.
Or clients' details.
And clients' details and contributors, cooperators' details.
Exactly. What is also important is that the trade secret and NDA agreement may differ depending on the market sector in which a given business operates. Just as an example, different type of NDA may apply to pharmaceutical business, to automotive business, to research and development active companies, and to other businesses where, depending on the nature of the confidential information, different types of arrangements in a contract can be made.
And coming to the sources of law, Poland is a member of the European Union, so we have two kinds of legal acts that govern protection of trade secrets. First is the national law on combating unfair competition, but also there is a directive, EU directive 2016/943, which protects undisclosed trade secret against their disclosure, use and use. And these two acts are of course harmonized within the harmonized the laws of the member states of the European Union within the organization. And the standard of protection which is provided by the directive is of course maybe even broader than the one provided by the national laws, and this concept of the trade secret may be different. But in Poland the directive is fully implemented. It has been already applied before the directive entered into force.
That's right, and what should be added here is that more and more we face transactions and projects which are of cross-border nature. This forms a kind of challenge and obstacle for businesses where NDA is governed by foreign law or which is subject to foreign jurisdiction. This is particularly important when Polish businesses, for example, deal with foreign business partners, no matter whether this is a joint venture agreement or R&D project or a startup discussing with their potential investors. In case an NDA is to be governed by foreign law and can be subject to foreign jurisdiction, it should be of particular importance for a Polish business to check the scope of protection vested under those foreign laws and to be careful about matching the relevant law governing the NDA agreement with the courts which have jurisdiction to resolve any disputes over it. Just as an example, particular importance should be made with respect to deals and transactions with Chinese entities, where there is no concept of a standard NDA, but rather Chinese entrepreneurs and Chinese practice, Chinese law and courts, they see and they accept the so-called non-circumvent, non-use and no-disclosure agreements, which are something a bit different than a standard NDA, which we understand under Polish or European law. And in this case, it is particularly important to be sure that in case we decide for a Chinese law governing such an agreement, we should also have the forum competent in such a way that we would easily enforce our NDA agreements towards our Chinese partners. And in that case, that should be, in many cases, Chinese court instead of a Polish one.
So, to sum up, you have to always see to your trade secret being properly protected, and you have to always put the NDA in place before you start negotiating if you are a startup or a big company with an established position on the market. Thank you very much for your attention.
Thank you.
Dziękuję.